This week we're talking about property law. I want to begin by making a distinction between real property and personal property. Real property is real estate, houses, buildings, and the things attached to them. Personal property is things that are movable and tangible, so not intellectual property, not copyrights, trademarks, and patents, but physical things that are tangible and movable. Within personal property, there are three categories that we should be aware of. The first is abandoned property, and this is a situation where the owner has purposefully parted with it, and in this situation we get our rule of finders keepers. The owner leaves that couch out by the side of the road, and you as the finder can pick it up and keep it because it is abandoned property. Lost property is property that the owner has involuntarily parted with. The finder is going to be able to hold good title against everyone except the true owner. So if you find it, mislaid property is property that the owner voluntarily mislaid and forgot about it. So they put it somewhere and then they forgot where they put it. In that situation, the owner of the place where the property was mislaid becomes the caretaker of the property because it's likely that the owner is going to be looking for it and may come back to that place to reclaim it. You may wonder, when does this ever actually come into play in the law? If you want to read a case about this, I would recommend the case of Popov v. Hayashi. It was a situation where Barry Bonds hit a home run ball into the stands during a San Francisco Giants baseball game. Someone caught the ball and then dropped it, and someone else got the ball. And so the court had to deal with this situation. Was the property abandoned? Was it lost? Was it mislaid? And the court had to go through that analysis to determine who actually had an ownership interest in the ball. As far as gifts of personal property, there are three requirements for a gift to be valid. There has to be an intent to give the gift. The gift has to be delivered. And then the gift has to be accepted. If any three of those items is missing, then the gift is not considered effective. The text goes on and talks about bailments. A bailment is a situation that is created when personal property is delivered without title under an agreement that the property will be returned to the bailor, the person who owns the property, or disposed of at the bailor's direction. A bailment can be structured to benefit the bailor, the bailee, or both. What are the rights of the bailee? The bailee is entitled to possess the property, to use it reasonably. The bailee may be entitled to compensation for, say, a sort of safekeeping that property for the bailor, and the bailee does have some limited liability. What are the duties of the bailee? The bailee has to use reasonable care. The bailee has to return the property to the bailor or follow the bailor's directions. Now, there are some special bailments, such as hotels and common carriers. We're going to hold them strictly liable if they fail to use reasonable care. They're going to be strictly responsible for the items that we entrust to them, our luggage and so forth. Insurance, just point out that insurance is governed by contract law. It is a contract, but it's also an area that is highly regulated. As far as an application for insurance, if you make a misstatement or lie on the application, it may be sufficient to void the policy. So my advice would be read your policy, especially a homeowner's or auto insurance policy, renter's policy. Make sure you understand what is or is not covered. Moving on now from personal property to real property. One developing area of real property law is the area of airspace rights. With the use of drones, this is going to be an area where we will probably see an uptick in litigation. Traditionally, this hasn't been an issue because airplanes and helicopters are traditionally flying at high levels so that they don't interfere with the landowner's use of airspace around his home or business. But with the use of drones, we may see more litigation and more clarification of the law in this area. Subsurface rights to minerals and other things that are under the ground. Those rights can be separated from surface rights. So if you have oil or gas or gold or something under your property, you could sell those rights to the oil company or the gas company. They could come in and remove those natural resources from the land, and essentially that's called a profit is the legal term for that, the right to come in and remove those resources from the land. A fixture is personal property that has been affixed to real property, things like cabinets or a hardwired sound system. There are two things to look at when determining whether something is a fixture. You want to look at the intent of the parties. Did they intend for it to be permanent? If they did, then it's more likely to be considered a fixture than personal property. And number two, what is the ease of removal? If we remove this, is it going to do damage, serious damage to the real property? If it is, then it's more likely that we would consider the item to be a fixture and be treated as part of the real property. Next, let's talk about some non-possessory interests in real property. These are rights to use property, but not really to own it. The first right is an easement. An easement allows limited use of someone else's property, and easements must be in writing. Usually they're incorporated into the deed for the property. And an easement is going to be binding on successive owners. So if you sell the property, that easement is going to go with it. If you live in a neighborhood with underground utilities, the electric company probably has taken an easement and they have the right to come onto your property if they need to work on those underground utilities. A license is similar to an easement, except it can be oral and it does not bind successive owners. A license is just a revocable right to enter someone else's land. So, maybe you give your neighbor oral permission to walk through your yard to get to the lake that's behind your house, and that would be a license. Now we're going to look at some interests that involve actual ownership of the property. The first concept here is something called fee simple. And fee simple ownership is the most complete form of ownership. We often hear of or think of property ownership as sort of a bundle of sticks. And if you have fee simple ownership, then you've got the whole bundle of sticks. Now, if we come down to the next level here, tenancy in common, in this situation, you're sharing your bundle of sticks with a joint owner or owners. And with a tenancy in common, any interest that you have in the property is going to pass at your death on to your heirs or beneficiaries. Similarly, a joint tenancy, there is more than one owner, so you're sharing your bundle of sticks. But the difference between a joint tenancy and a tenancy in common is that with the joint tenancy you have this right of survivorship. And so any interest that you have is going to pass at death to the surviving tenants, the other owners of the property. So your heirs and beneficiaries are going to be out of luck. Tenants by entirety is essentially a special type of joint tenancy for a married couple. It's joint ownership of land by a husband and wife, and the right of survivorship is going to be automatic. Community property. There are only 9 states in the United States that are community property states, and Tennessee is not one of those. But in a community property state, any property acquired by a husband or wife during the marriage is considered jointly owned by the couple. Our last type of property ownership that we'll talk about is the life estate, and really if we're talking about our bundle of sticks, this is probably the situation where you are left with the fewest sticks from the bundle. A life estate is an interest in property that lasts for the duration of an individual's life. And during that time, the person may inhabit the property, live on it, use it, but cannot sell it and cannot commit waste, meaning they can't do things that are going to bring down the value of the property. Deeds are the way to go if you're going to transfer ownership of real property, and there's some different types of deeds you should be aware of. The most common is a warranty deed, and this is the kind of deed that you're going to see if you are buying or selling a home in a regular transaction. The warranty deed assures that the seller has clear title to the property, that the seller has the right to sell the property, and that the seller is going to settle any claims that arise. So if something comes up down the road, the seller is going to try to help rectify that situation if there was a claim against the property that they didn't know about, or whatever the case may be. A quitclaim deed is a deed that conveys whatever interest the seller has, and there's no assurance of clear title. Where you'll usually see a quitclaim deed is if there's a divorce and one spouse may quitclaim his or her interest in the marital residence to the other spouse. A deed of trust is going to be used if the property is mortgaged. The lender or the lender's agent is going to hold title to the property through that deed of trust until the mortgage is paid off, and once it is paid off, they will file a release deed releasing their interest in the property, and it will be fully and completely yours. There is one way that ownership of real property can transfer without a deed, and that is through the concept of adverse possession. And you can think of this sort of like squatters' rights, I guess. But here are the requirements. In order for title to pass to a new owner by adverse possession, the adverse possessor has to actually be on the property. They have to actually physically occupy and use the property. Their possession of the property has to be open and visible, so not something secret or clandestine. It has to be open and visible. Their occupation on the property has to be continuous for a set period of time, and usually there's a statute that may designate a certain number of years, 10, 15, 20 years, that the adverse possessor must be in possession. And lastly, the possession has to be hostile. In other words, the possessor cannot be living there with the owner's permission. If the owner gives permission, then the possession is not hostile. Let me go back to that requirement of continuous possession. There's something called tacking, and tacking is the concept of adding periods of occupancy by different people to see whether title can pass by adverse possession, and it helps meet that continuous occupation requirement. So I guess the lesson here of adverse possession is that if you own property, you should keep tabs on it. Make sure that there's not somebody living there using it without your permission, because if they are, and they do it long enough, you run the risk of losing ownership of that property through adverse possession. The last way that ownership of property might transfer is through something called eminent domain. That occurs when the government condemns or takes property for any public use, and the phrase public use is in quotation marks there because that's the language that the courts have used. Public use traditionally was things like roads, parks, schools, things like that, though the courts have recently taken a broader view of public use and have even allowed property to be condemned and taken for economic development. Of course, if the government does take property, they do have to pay the owner some reasonable compensation. And we're going to end our discussion of property here by looking at leasehold estates, or essentially the landlord-tenant relationship. There are different types of leasehold estates that can be had. The first is a fixed-term tenancy, which is a lease for a fixed period, 6 months, 1 year, 5 years. This type of tenancy does not automatically renew. Once the period is up, then the leasehold interest reverts back to the landlord. A periodic tenancy is a lease for an indefinite period of time involving payment of rent at fixed intervals, month to month, for instance. This type of lease is going to automatically renew unless one party gives proper notice of cancellation, and usually the amount of time required for cancellation is going to depend on the length of the periodic tenancy. For instance, in a month-to-month tenancy, you probably have to give a month's notice. Otherwise, without that notice, the tenancy is going to automatically renew. A tenancy at will is a lease for an indefinite period of time, and either party could cancel at any time. Tenancy at sufferance is a situation that is created when the lease ends, but the landlord either lets the tenant remain on the property or the tenant just refuses to leave, and then you have a tenancy at sufferance. So what are the rights and duties in this landlord-tenant relationship? Well, as far as possession, the landlord should have the property available to the tenant for the tenant to take possession at the agreed upon date and time. As far as use of the property, the landlord should guarantee to the tenant the right to use the entire leased property. That's called the covenant of quiet enjoyment, that the tenant should be able to enjoy the entire leased premises. As far as maintenance goes, the tenant, of course, should report any damage and may be liable if the tenant caused the damage. But on the flip side of that, the landlord has to comply with what's called the warranty of habitability. And this just requires that the property be fit for habitation. So, you can't have raw sewage coming up in the bathroom or lack of running water or things like that. That would render the property inhabitable, and the landlord could be liable for violating that warranty of habitability. As far as rent, of course, the expectation is the tenant will pay rent, and if the tenant fails to pay, the tenant can be evicted, and there's certain notice procedures that go along with that. There's also something called constructive eviction, and this could come into play if the landlord is not living up to that warranty of habitability. If you don't have running water, if there's sewage coming up in the bathroom and the landlord isn't fixing it, or there's some sort of serious issue that makes the home uninhabitable, then you can make the argument that you have been constructively evicted. All right, and so that's an overview of real property and personal property.